With the Apartment Owners Association, and it is great to have you with us today. If you're in the Zoom, you've already heard a whole bunch
Yeah.
about rent reporting and about the AOA lease, and you've been privy to that. And if you're watching from YouTube, now you're joining the call. So definitely next time around when we have the Zoom call, join the Zoom call because we're going to answer questions first in the Zoom. Not all of our live streams are Zoom too, but this one definitely is. And again, it's great to have you with us. AOA, we've been around for over 40 years. Thank you. I know most of you are members. Some of you are new members, and some of you are outraged members on the call because we've definitely gotten that response from a lot of owners. You're feeling harassed and you're wondering why is the tenant protect there's this anti-harassment thing, but what about us? We're being harassed and being told we for our own house we have to register. What is this crazy stuff? So we
Yeah.
have Dennis Block with us today. He's going to go over that. Y'all know Dennis. He writes the legal Q&A in the magazine. If you're not reading that monthly, you should. He has his own channel. If you haven't subscribed to that one, you got to go over there and subscribe. Just search up Dennis Block on YouTube. If you're an AOA member that is watching from AOAUSA.com, AOA also has a YouTube channel, and that's what this one is being broadcast from right now. It's AOA USA. So I just recommend that you subscribe to that. Sometimes we put stuff up that is not an event. And whenever you miss events, you can always just go over there and watch it when when it's convenient for you and you don't have to, so you can kind of get everything done that you need to get done and then watch it when you can. All right. So great to have you with us. We are dedicated to your real estate success. Recently, we've had a lot of questions about rent reporting and AB 2747. For those of you with 16 units or more, 16 unit building, not 16 units in total, but a 16 unit building for the majority of you. You just need to send out an email offering the service, and then AOA does have a white glove service that you can opt into, and so there's a process with that. That's something that you can do. That's just another AOA member benefit. It's $5 per renter for that, and then we have the property management software where if you're subscribed to the property management software, it's actually free for the renter. It's free for you. And we're even giving them an Amazon gift card, each renter that opts in. And what we were talking about before we went live on YouTube is just how there's very few renters that want to opt in. But it is really, it's a great thing for people who are looking to build credit and one day buy a house. That's kind of really the subset of people that really would benefit from it. And I think everybody would benefit from good credit. You don't want to use it necessarily, but you want to have it for when you need it. And anyway, so that's the rent reporting stuff. I hope that makes sense for you. And man, we are at the end of the month in April. In a few short weeks, we are going to have the big AOA $1 million trade show and landlording conference. So we want to invite you to that. There's going to be over 20 different speakers. Dennis Block's going to be there, and a whole just a great list of other speakers. In addition to that, it's not like Dennis is just speaking or other people are only speaking. They're there all day and they're taking questions all day long. And so this is a great time to come out, get your questions answered. All kinds of vendors are going to be there, so you can meet people face to face. A lot of them are raffling off different prizes. We are definitely raffling off the 5-day cruise for two at every single main main stage seminar, and we have the Apple Watch that we're raffling off at the very end. And anyway, it's going to be a great day. I really encourage you to show up. And if you've never been before, definitely want to go. If you don't have an AOA membership, never have had one, we do give you a free 6-month membership. So if you're an AOA member, bring your friends. Maybe it's bring your your son or daughter that's of age and let them get a free AOA membership, maybe, whatever it might be. And anyway, we're really looking forward to that. But yeah, so here we are. Dennis Block, you've done your workout today. I've done my workout. We made our bed. We've actually already accomplished a whole lot by 10 a.m. And here we are. And for everybody that, yeah, anyway, I'm about to go off on a tangent, but I won't. Hey, Dennis, tell us what you know about the Just Cause ordinance and what the registration requirements are.
Well, thank you very much, Jeff. Always enjoy doing these broadcasts with you. And obviously, for the AOA members, this is such an invaluable tool because this industry, based on our politicians, just keep changing the laws. And it's very difficult to stay informed. And obviously, the Apartment Owners Association is the premier apartment association for the state of California. And quite frankly, the knowledge that you guys get from this is invaluable. It just protects you from lawsuits and makes sure that you're in compliance with the ever-changing laws. With regard to that $1 million trade show coming up on April 16th, Jeff, you should tell everybody that it is at the Los Angeles Convention Center. And of course, Mission is going to be free. And I highly recommend that you go down there. Not only are you going to hear all the speakers, and it's not just the legal stuff, but you're going to get, investment brokers, insurance brokers. And literally, there's going to be, I don't know, hundreds. I don't know how many booths you got there, but you're able to walk up. And I'm telling you, if you attend this convention, you'll learn how to operate your buildings more efficiently and learn how to make more income. So it's free. You come out there, and also if you stay around to 3:15 in the afternoon, you'll get to see me speak, and I'll have a booth there, and we have handouts, etc. So that is with reference to our $1 million trade show coming up on April 16th. Also, on this meeting here, we have people in YouTube Live, we have people in the Zoom meeting. If you are in the Zoom meeting, I suggest that you electronically raise your hand now because at the end of the present, actually call on you and keep your camera on. We'll be able to see what you look like. Also, if you're in the YouTube Live, you can list your questions and Jeff will read the questions and I'll see if the old man like myself can answer those questions. Okay, what's the topic at hand? And the topic at hand, and actually before I get into the topic at hand, I want to tell you that the opinions expressed by Dennis Block are not the opinions necessarily of the Apartment Association or our good friend Jeff Fowler, because what I'm about to say certainly will be my own personal opinions, ladies and gentlemen. Okay, so what's going on now? The city of Los Angeles has passed an amendment to their Just Cause ordinance, and that deals with the fact that it's forcing all residential property owners to register their units. All property owners, residential property owners now have to register your units. Before, if you were under the rent stabilization ordinance, that is properties built prior to October 1st, 1978, unless you were a single family home, you had to register your unit. But now they've come back and they have now created this just cause ordinance. That was a couple of years ago. And now the amendment requires every single residential unit that is not under RSO. Now you have to register that unit. So you know that Brentwood house that you're leasing out for $45,000 per month? Well, guess what? You've got to register that unit. Let's pretend that you don't even lease the unit. You still got to set up an account and you still have to register your unit. So, what was the point of the Los Angeles City Council and our wonderful Mayor Betts in instituting this amendment to the Just Cause Ordinance? And it's very simple. It's just a total money grab. That's the only reason why they have created this situation, because now every single residential unit that wasn't under RSO now has to be registered. And guess what? You have to pay a fee. for every single. So the money coming into the city based on this boondoggle, which has no reason to exist, and I'll go into that, will be for one purpose and one purpose only, and that is our city is facing a big deficit, and they figure, oh, well, let's pick a target. Well, who's the target, ladies and gentlemen? It's only one target, and that's up and down the state of California, but certainly in LA County and certainly in the city of Los Angeles, and that is income property owners. We're the villains because merely we provide a service. We're allowing housing providers for people who are in need of housing, but yet we're the villains. So let's start with a little bit of history. Rent control started in the city of Los Angeles in 1979. And I know it because I was practicing law and representing landlords at the time. And all economists agree that the institution of rent control only makes prices go higher. It is true. And that's because when you institute rent control, you have a shortage of housing units. And when you have less supply, then you have more demand. And that's the way it works in economics. In fact, they've done studies that even in LA County, the cities that didn't have rent control, like where my office is right now in Burbank, a civilized place to own property, I might add. If you those units, those cities that didn't have rent control, their rents were lower than those cities that had rent control. So if the politicians were really trying to make more affordable housing, the last thing you do is to have a rent control. But of course, logic never befalled on the members of the city council or our mayor. Now, every time a city institutes rent control, you have to have another statute dealing with good cause to evict. I mean, logically speaking, if you didn't have that statute where you require good cause to evict, in other words, you just can't serve a 30-day notice or a 60-day notice to vacate on a month-to-month tenancy. You have to have good cause to evict because if you didn't, the city belief is that landlords would easily circumvent rent control by just serving a notice to quit. So therefore, you had to have good cause to evict. So the city invented rent control back in 1979, and it affected all residential units with these exceptions. It only applied to units built before October 1st, 1978. So then you were under LA rent control. The only exception was if you had a single family residence. And under the rules for RSO, the Rent Stabilization Ordinance, you had to register your units and you were limited in terms of what rent you could charge. If your property was built after, obviously you didn't have to register your unit and you weren't subject to any kind of rent control. Okay, let's move forward in history again. And now we're going to go to March of 2020. Well, guess what happened? There was a national disaster in March of 2020, and it dealt with the concept of COVID. So, of course, the city of Los Angeles and most municipalities in the state of California decided that because of this national emergency, it was necessary to put the financial responsibility of the harm that this caused by this disaster solely on the shoulders of income property owners, solely on the shoulders of income property owners. No other industry had to face the financial disaster that income properties had to face. Again, our industry singled out like no others. If you don't believe that, well, number one, if you had properties in, for example, in the city of Los Angeles during the COVID period, you were not entitled to a rent increase for 4 years. And that's notwithstanding the fact that we had tremendous inflation during that period. What other industry during the COVID period told the purveyors of those industries that you couldn't raise prices? What industry was that? Oh, I know, no other industry. So we were totally singled out for that. In fact, what other industry was told that you couldn't enforce your contract rights? Let's think about it. Oh, I know. It was only income property owners because we weren't allowed to do an eviction based on non-payment of rent, unauthorized persons, or animals during this period. The losses sustained by income property owners during the COVID period was staggering. And then begrudgingly, the city of Los Angeles, 3 years after COVID was actually over and did not impact anybody, begrudgingly, they finally opened up the floodgates and allowed landlords, in this case, a lousy 4% rent increase for RSO properties, and allowed us to go forward with evictions finally. So what did they do? In the face of finally allowing things to get to normal, they started something called the Just Cause Ordinance that was instituted on January 27, 2023. And that impacted all other units, including single-family homes, regardless of when it was built, regardless of who owned it, a corporation or an individual. All other homes that weren't under the RSO were now subject to JCO, the Just Cause Ordinance, okay? So you had to have good cause to evict your tenant. Okay. So I've got this single family home and it's in Brentwood. I've got a tenant in possession and I want to sell my house. Sounds reasonable. People want to sell their homes, correct? So of course the tenant's on a month-to-month tenancy. And I'm going to serve him with a notice to quit, 60-day notice. He's been there longer than 1 year. If he wanted to leave, he could legally leave. He'd just have to serve us with a 30-day notice to leave. But as you see, under JCO, the Just Cause Ordinance, that's not a ground to evict. You're kidding me. No, I'm not kidding you. You need good cause to evict, and I want to sell my house is not a cause to evict. You can evict, of course, for non-payment of rent, violations of the rental agreement, like they brought in extra dogs or something like that, or people. But you have to have specific grounds, and incredulously, you have to have specific cause, and that is not that I want to sell my house. So you've got all these people out there with tenants in possession. Now, it used to be that you could ask a tenant to move on the basis, this is for JCO properties only. You could ask the tenant to move because you wanted to do major renovation. Well, guess what? About 2 weeks ago, the city council and our wonderful mayor, and I use that term very loosely, stated that that is now not a cause to evict, that you want to renovate your unit. That is now not a cause to evict. Now, they created some more laws under this ridiculous JCO, the Just Cause Ordinance. And that is that anytime, and this is for any residential unit in the city of Los Angeles, you have to upload that termination notice. So if you're serving a termination notice on one of your tenants, like a notice to pay rent or quit, or a notice to perform or quit, you have to serve that notice by uploading it to the city. You've got 3 days to do it. And if you don't do it, that's considered a complete defense in an unlawful detainer action. So why did the city institute that law where you have to upload these notices to the city? Obviously, you would believe that they want to check the notices to make sure that you're in accordance with the law, and they could obviously send you a notice that you're not. But you see, I've been in contact with the Los Angeles Housing Department, many of their staff members. And do you know what they do with regard to all the notices that are uploaded that you have to upload within 3 days to have a decent case for eviction? Do you know what they do with it? Nothing. They don't look at it at all. So on what basis would you want us to upload all these notices to the city if the city is not reviewing these notices and not doing anything with it? It's very simple. They want to have tenants' attorneys have a defense. So they create a law for no particular reason that if you walk on the right side of the street versus on the left side of the street, you can be fined. But there's no way anybody's going to know this. And there's no reason for that, what side of the street you walk on. If you're not going to review these notices, what is the point and having us upload these notices to the city. It's just a boondoggle for landlords to lose their cases and, quote, more and more tenant protection. But it gets better. Remember, if your property is under the just cause ordinance, that doesn't really involve rent increases. You can raise the rent to whatever is legal. There you do have some limitations with regard to if your property is under statewide rent control. But for example, if your property is a single family home, a townhouse, or a condominium, then you have no rent limitations. You can raise the rent to whatever you like, whenever you like. I don't care who owns it, a corporation or REIT, makes no difference. If it's a single family home, a townhouse, or a condominium, you can raise the rent to whatever you like. So, okay, what's another part of this wonderful JCO, which is totally illegal? And that is something called economic displacement. Economic displacement. What the hell could that be? Well, I'm ready to tell you. If you raise your rent, and you have the right to do it, more than 8.9%, then that triggers economic displacement. So if in fact your tenant says, you know what, you're raising my rent. I know you have the right to do it, but you know what, it's too high and I'm just going to leave. And you're thinking to yourself, well, that's great. I'm very happy that you want to leave. Okay. But then he's going to say, well, where's my relocation money? And you say, what are you talking about? I'm just raising your rent. Pay it or leave. I don't care. Well, you see, the city of Los Angeles created this economic displacement chart, which means if the tenant says, I don't want to pay the rent and I'm going to move, you have to pay him relocation. So what's the relocation? If it's a single family home, it's 1 month's rent. If it's a 1-bedroom apartment, it's $7,654. If it's a 2-bedroom apartment, it is $9,286. Well, this is insane. For a 3-bedroom, it's $11,416. Why do I have to pay my tenant money relocation if I have the right to legally raise the rent? And the answer is there is no justification. This is just another boondoggle by the city of Los Angeles to put so much financial pressure on landlords because they sell their buildings. And it is my belief the reason why they do that is because the city and the county want you to sell your buildings. And why do they want you to sell your buildings? Because then it'll get reassessed and you'll be paying more property taxes. And they really only want big corporations to own your buildings. And they're trying to corner the market. Remember, I said this was Demsbach's opinion only. They wanted to corner the market so that they're only dealing with the big institutions. But that's what they created when they made this JCO, the Just Cause Ordinance. But does it get worse? And of course it does. They came up with something called the fair market value, which affects not only RSO properties, but it affects JCO properties. It also impacts properties that are in unincorporated area of LA County. So what is this story all about? Well, let's pretend you have a 1-bedroom apartment and the rent is $2,000 per month. And the tenant doesn't pay you March's rent. So you go to the OA website and you fill out their 3-day notice form, which is excellent, I might add, and steers you into not making a mistake. And then you file it with the city because you listened to this broadcast and you knew to upload it to the city. And then you filed your lawsuit. Well, guess what? You've already lost. Well, how is that possible? The guy owes me the money, it's $2,000. But you see, they created something called the fair market value threshold. The fair market value threshold. And I know what you're thinking. What the hell is that? Well, I'll tell you. You can't serve a 3-day notice unless the notice exceeds the fair market value threshold as established by the Housing and Urban Development. So for a 1-bedroom apartment, the fair market value for this year is $2,006. For a 2-bedroom apartment, it is $2,625. For a 3-bedroom, it's $3,335. So in my example, the rent was $2,000 for a 1-bedroom apartment. But the threshold, did I get that right? The threshold is, oh, I'm sorry, the threshold is $2,081. So on that basis, I can't serve a 3-day notice. Well, then how am I ever going to serve it? Well, you're going to have to wait till April. So in April, he'll owe you 4,000. Now you're finally above the threshold. So now you have the legal right to go forward with an eviction. No other city in California has this except for the city of Los Angeles and the unincorporated LA County. And that's why Jeff is going to send to you at the end of this broadcast how to have Mayor Bass mayorship revoked so we can get her out of office. Make sure you have that ready, Jeff, okay? So in any event, we have to go through the fair market value. And by the way, I always talk about if you have a Section 8 tenant, forget ever trying to evict them based on non-payment of rent, because we all know under Section 8, you have subsidized housing. So the tenant's only paying a small portion of the total rent. And if his portion is only $200, before you got there, you'd have to wait 11 months. So the city, in effect, has banned evictions for non-payment of rent for Section 8 tenancies because you'll never get above the threshold. Now, remember when I started off with the original rent control ordinance, I said that logically, if you're forced to do a rent control ordinance, logic would say you'd have to have good cause to evict. Because otherwise you just tell the tenant to move and you could easily get around it. So anytime you're of the persuasion of starting a rent controlled statute, then you have to have good cause to evict. But what's the rationale of having good cause to evict if I'm not relegated to limiting your rent increases? If I'm not relegating to limiting your rent increases, why do I need just cause to evict? Why would a landlord want to have some tenant moving out if I could charge whatever I want? I mean, unless the tenant's a nuisance or something, there is no justification for it. I'm not trying to get around the system because there is no system to get around. I'm not limited by rent increases. So on that basis, why would you have the just cause ordinance? Well, that gets back to my opening topic, and that is it's just a money grab. Our city is in high deficit right now, without having any water and fire hydrants, I might add, to the chagrin of those people in the Pacific Palisades. But yet, money grab so that they can use money for projects that I don't believe anybody in this city wants. So this new Just Cause Amendment started exactly 2 years after the Just Cause Ordinance. The Just Cause Ordinance started January 27, 2023, and incredulously, the amendment 2 years later, January 27, 2025. So what does this lousy amendment talk about? Well, this requires that all units subject to JCO be registered and pay a fee. Oh, really? What's the fee? $31.05. So if I have a 20-unit building that was built in 1980, subject not to RSO, but subject to JCO, you're going to have to pay $31.05 for each of those 20 units. So that's around, what is that, around $620 approximately. Now, if your unit is not leased or is maybe owner occupied, or you put your daughter in one of these units, then you're forced to file a yearly exemption. You've got to go online and file a yearly exemption. Now, I know landlords were getting this letter, or property owners. I don't even want to say landlords. So I'm going to show you what the letter looks like right now. So bear with me. Did I do it? I think so. So that's the letter right there. And this is what landlords were getting. They're saying, why am I getting these letters that talk about the Just Cause Ordinance? Okay. Well, you got these letters because you have property in the city of Los Angeles that they know is not under our SO because they know which those are. So they sent these out to property owners. And even though you are living in the unit yourself, or the unit is not registered, or the unit is vacant and you don't, or maybe you have two residences, okay? So the people who got this were people that the address of the premises was different from where the tax statement is mailed from the county assessor's office. So that was the secret. They mailed it out to anybody whose address on the deed, the mailing address on the deed, differed from the property address. So everybody got this and they didn't know what to do with it. And then they're told that um, they were told that they had to register their units. So there was a website they told in this letter here, and the website is the housing bill, one word, lacity.org/billing. Once again, housingbill.lacity.org/billing. So they told you to go there and register the unit. And then, because of the boondoggle of the city, when you're trying to register the unit, they said you needed a statement number. But they didn't give you a statement number. And then they were telling you that the deadline was February 28th, which they've now elongated to the end of April now. So now you have to wait for the city to send you a statement. And when they send you a statement, then you can finally register because now I have a statement number. And then you can either pay the $31.05 per unit, or you can say you're exempt for the reasons listed, that it's either not rented, it's vacant, or it's owner occupied or a family member occupied. Okay. So, and by the way, if you're desperate to get a statement, if you send, my clients have told me, if you send a letter to the Los Angeles Housing Department, an email, and saying, I need a statement number, they will send that back to you. So, this is what we're faced with, that you're going to have to register the unit. Now, the fact that you didn't get it based on the way the law states, because the address of the property is the same mailing address on the deed, the fact that you didn't get it, okay, deals with the fact that it doesn't mean that you still have to register your single family home that you're living in. If you get a single family home, I would never be a landlord. I don't care about being a landlord. I've lived in this house for 20 years. Based on the way this idiotic, insane law was written, you still have to register that unit. So what's the penalty if you don't register the unit? What's that penalty? It's 150% of what the registration fee is. So that would be $31.05 for the registration fee. And then 150%, which is about, I don't know, $46. So this is absolutely insane. However, I am proud to tell you that the city does have a justification for why they're charging these JCO fees and why they're asking you to register your units. And they do have a stated purpose, and I'm going to read that to you. So here we go. The JCO fee provides programming services and related expanded tenant protection for tenants citywide, and it is administered by the city. That's their justification. Now, I don't know about you, but I have no idea what I just read. You have any idea what I just read? I don't. I'm going to read it again. The JCO fee provides program services, and related expended tenant protection for tenants citywide, and it is administered by the city. I don't know about you. I can understand English. I don't know what that says. I don't know what it's going to be about. But what they're talking about, it's going to fund investigations into tenant harassment claims against their landlords. Tenant harassment claims. So that if a tenant files an harassment claim, which the city has this procedure for doing it, then the city can go out there and check it out to make sure that the landlord is not harassing the tenant and possibly fine the landlord for harassing the what they need is they need a tenant harassment against the landlords is what they need. That's the ones who are being harassed I can tell you this on a daily basis from my clients as to who the harasser are and who's the harassee in these types of situations. But I do want to let you know that for the last 3 years, it was reported in the Los Angeles Times as of August 19, 2024. For the 3 years prior to that, there have been, and this is legitimate, reported by the LA Times, and we know what an honest publication that is. I'm just waiting for Jeff to laugh. Uh, there have been 13,000 complaints of complaints about landlords. Tenants have complained 13,000 times in the last 3 years, and that's actually kind of a sizable number. However, let's move on. Of those 13,000 complaints, the city found that the landlord harassed the tenant 4 times. 4 times out of 13,000. You can imagine how landlords were harassed by having to defend themselves by these phony harassment claims where only four out of 13 were found to be valid. Getting the city attorneys involved, only 4 got fined. So why does the city need to register your unit to grab all this extra money? Because they say they need to enhance tenant protection because of all these harassments when there isn't harassment on this. What is the point of that? So make no mistake, there's only one reason why this was created. And again, it's just a total money grab by Mayor Bass and the City of Council because they're facing a deficit. And look at all the more money that is going to come into the coffers of the city so that they can spend it on pet projects which do nothing for nobody, including if your house is burning down, that you can't even get protection from the fire department. And I want to end this with the following. Shame on you, Mayor Bass and the City of Council of Los Angeles. You do no good for the city. There is no social services that you provide of any quality for the citizens here. And as I always say, the best thing to do is get out of Dodge. And with that, Mr. Jeff Fowler, we can open it up to questions.
Wow, there's some editorial content right there.
I exempted you from it. Come on.
Yeah, no, yeah. Anyway, what do you think, guys? What do you think? Uh, but really, yeah, there's a permanent exemption you can get when you file it with the county assessor's office. Is that correct? Have you heard of that?
I have not.
Okay,
I
that's
said
what,
I read that you have to file it yearly. So
right. It has to be filed yearly. I believe that there is one. You could file it with the county assessor's office where it would be permanent. But don't ask me how to do it because I didn't get the notice at my house.
you will. Otherwise, you're going to get fined 150%.
So, all right. So, if you are watching on AOAUSA.com, there's the blue help button. You can put your questions in there and we can get those answered. Anybody in the chat, or I'm sorry, anybody on Zoom, you could go
Zoom,
ahead.
if you electronically raise your
Oh,
hand,
look,
it's in
there's a
the
few in the chat.
toolbar.
So, here we go.
They're allowed to. We can
Right.
call on, otherwise we can do the chats from either Zoom or from the YouTube Live.
Yeah, we have one in the Zoom here. Okay. Are you saying that basically everyone in LA County has to register their single family home or just the properties that we rent out?
My understanding is that you have to start a registration and then you have to file your exemption. You got to do this yearly. So for the old grandma who's lived in her house for 50 years, based on the way this law was written, this is what you're going to have to do.
Okay, so let me see. And then what if they didn't get the letter? They didn't get the letter because, like you said, if you're paying for the property tax from the same address, then you're not going to get the letter. Is that what we're?
Yeah. So, but yet the law states that you have to, if you have a single family home or any residential property, you have to register it, and you can file an exemption like I live there. So this makes absolutely no sense.
Right. And then Peter, this is a long one. Let's see. I have a single family home in NELA with two. I'm sorry. Oh yeah, keep yourself muted unless yeah. Two wonderful tenants on a month-to-month lease recently received the JCO notice. Tenants are a couple in their 50s, no kids, no disabilities, there since December of 2017. Great relationship with them and have always said that if we ever decided to sell, we would give them warning. Recently, before the JCO notice from LAHD, I told them that we had decided to finally do it, but with no specific timeline. Since then, they've started looking for a new rental, and because I am a realtor, I started helping them look for a condo. As it is now, they're probably going to leave on their own. If they change their minds and decide not to leave, I assume that we could list it with the tenants there, estoppel certificate, etc. Is this is not ideal for a number of reasons, but I understand that the new, assuming owner occupied owner would arrange the eviction during escrow and pay the 1 month's worth of relocation rent at the close. Can the JCO throw a wrench in the sale?
Well, they already have thrown a wrench in the sale because you can't ask a tenant to move because you want to sell the property. Obviously, if you're going to market this property, who's going to want to buy the property with a tenant in possession? And now you've got to go through, if you want to move in, you're going to have to go through that procedure and pay relocation. So you're making the property unmarketable. So what do we have? It's very simple. You have a total trampling of our property rights by our politicians. There is absolutely no justification for this statute. Again, the statute doesn't deal with trying to limit rent. So if you don't have it tied to a rent control statute, what other issue is there other than what they had in mind when they did this back in 2023? They realized they would wait a little bit, and now let's institute a way of now charging people for this. So this was all planned, and they did it to the day, January 27, 2023, January 27, 2025. 2 years later, they instituted this. They knew exactly what they were going to do.
All right, Sylvia on YouTube. What is the difference between JCO and she has RCO, but probably means RSO? So,
Well, obviously, the RSO, you're limited by rent increases. This year it's 4%. Again, RSO properties are any properties that was built prior to October 1st, 1978. Obviously, there's no limitations ever for any property, regardless of when it's built, for condos, single-family homes, or townhouses. But if your property is prior to October 1st, 1978, you do have to register your unit and you are limited to the rent increases. Post 1978, again, you need just cause to evict. But why do I need just cause to evict if we're dealing with properties that's not subject to the rent stabilization ordinance? So it makes absolutely no sense.
all right, Devon. Does this apply to single family homes located in Reseda, West Hills area? So yes, it would. That's part of LA City. And a lot of people, yeah, they're not aware of when they say the city of LA or LA City that includes the valley, unless it's like San Fernando, which is its own city, or parts of LA that are would be considered unincorporated LA, right?
Yes, correct.
All right, next question here. How can the city of LA enact a law for LA County?
I think it's the other way around. How can LA County enact for the city of LA County? And what I think you might be referring to is that if a tenant claims that they were the victim of a fire, either because they lost their homes or because they have less income because of the realities of what the fire uh, did to people's income, then they have a buy of collecting rent from February of 2024, excuse me, February of 2025 through July of 2025. You can't evict a tenant if they have served you notice by the 7th of each month saying, hey, my income was down 10%. I did apply for wildfire relief, etc. So, um, And the county was made this law and said that this law applies to everywhere in the county, including incorporated cities of Los Angeles County, uh, unless they have their own law in place. Well, of course, no other city has their law in place. So that's how the county now has usurped the authority of all the other municipalities. So where tenants can claim that they're victims of the fire and now not pay rent from February to July of 2025. And guess when they have to have the right to pay it back? And that is 1 year from July of 2025. So they get till July of 2026 to pay back that, I think, 6 month period.
Wow. What are you going to invest in for
Uh,
6 months?
I told you I'm getting out of Dodge. I won't invest in the state of California anymore. So,
No, I
but
mean,
everybody, if I
you're a
want
renter. What are
everybody
you
to
going to put your
follow
money
my
for?
lead, and then what I would like is, the AOA has the unbelievable real estate division where they will sell your apartments. So please get out of California and list every building with AOA because they're great.
Yeah, no, it's really not that. We do love LA and we want to I mean, I know some people are leaving, have left already. But yeah, we're here to stay. Maybe you are too with me on that, maybe not. A few other questions here. I assume that most people are not aware of this law, referring to the
JCO.
JCO. They are living in their home forever and they haven't received a letter. If they haven't received a letter, they don't owe this, do they?
I don't think so. I'm not sure what procedures the city is going to do. I think there'd be like a run on the city hall if all of a sudden someone say, "Hey, you didn't do it." Well, you never sent me a letter. Well, I don't have to tell you that, what the speed limit is either. But I don't think they're going to do that. I think they were just trying to institute this for where they had a suspicion that the unit was rented out, and that would be where the mailing address for the tax bill is different than the site property.
And then Susan Rodriguez, I think she's referring to the LA County, what they've come up with. How are they able to infringe on our business?
Well, I think I just stated that with regard to that they can stop eviction lawsuits for failure to pay for that period of time. But I mean, these laws are there. They're being challenged, and unfortunately, you live in a crazy liberal state, and on that basis, property rights are just thrown out the window.
Do you know of any lawsuits right now against LA County?
This economic displacement lawsuit where you have to pay them money if they choose not to accept a lawful rent increase, that one is being challenged, and I would predict that would be thrown out. I mean, they overstepped their bounds on so many things.
And then for the one with the fires, um, and how they're trying to usurp the authority of the cities within LA County, is that you don't know of anyone that has a lawsuit regarding that one, do you?
No, in fact, that just occurred within the last week or two.
You
Maybe the
probably
Pacific Legal Foundation might be jumping on that one.
right. Yeah, like we've been in contact with the constitutional attorney that we have, and we haven't. I think we need a little more time before we would have a lawsuit if we're going to have one. So we'll see. We'll keep you posted. And so thank you. I know some of you continue to give to AWA PAC, Political Action Committee, and we save those dimes and nickels, everything that we're getting there. We save that to be able to have lawsuits when things are written the way they are. And that one, LA County, the way that is, it just seems like it's ripe for a lawsuit. Um, but I think there needs to be damage before there can be a lawsuit. And I don't know that anyone's been damaged yet. We'll see. Devon, does this apply to single family homes? Oh, it just got reposted, but no, it does not apply to single family homes. I'm sorry. Yes, it does. In Reseda. Yes, it does. Okay. Brown Eyes, when I went on the DCBA website, there's something new that was added. What is small property landlord self-certification form?
Not for me with that. I know you have to register your units. I'm not sure what that form is, but I do know another little trick that when you serve a 3-day notice, this is brand new, for unincorporated areas of LA County, you have to serve an additional form which tells them that they have the right to an attorney. It's a form that the county has. If you
Mm.
don't serve that form, guess what? You're going to lose your eviction case. It just goes on and on and on.
Okay, what was that form again? LA County form. If you're serving an eviction notice, it says that.
Yeah, it's called the attorney right to an attorney, and I'm pulling it up here if I can. Yeah, attention tenants, notice of tenants' right to counsel. Here, actually, you know what? I got this down here. Let's do that. And I am going to share that. There it is. See that form?
Okay.
That's it. You've got to serve that form. I hope no tenants attorneys are listening to this, quite frankly. You've got to serve that form with your any type of a termination notice. If you don't serve that form, then technically that's a defect. It's just insane. That form came out in January.
Mhm. All right, Sylvia, does Ventura County have the same restrictions? And they don't. They're land of the free, right?
A civilized place to own property is in Ventura County.
Okay, Sandra, the interest rate for retained deposits was raised from 0.01% to 4%, or maybe it was 0.04% to 4%, I believe. Why the big jump? Why do we have to pay interest to tenants?
Well, I mean, we're getting kind of 5% interest in our bank account, so they're supposed to tie it to that. During the last few years, it was very low. Technically, you're giving the interest that you actually got or what the stated is in their bulletin. I know I have that on my website, or you can just do a search for interest on security deposit Los Angeles, and you'll see it from year to year. But there was a big jump. I think it's more. I believe it was like 4.3%. It's insane.
Yeah, yeah. So don't follow those numbers 100%. Those are estimates just thrown in there. What is the best way to approach a tenant? And I guess how do you avoid tenant harassment when you need to do business with your tenant is kind of the question. And maybe that should be a life.
I mean, the best thing is really to document everything. You send them letters saying, "Hey, you asked me to fix the garbage disposal on this date, and I completed on this date. Thank you for letting me know." I would document everything. Take pictures of the unit, obviously before it's leased. When you go in there and do a job, for example, a plumbing job, take a picture of the completed job. This goes a long way to prevent harassment. But these people will say, I walked by my landlord the other day. He didn't say hello. I'm filing an harassment claim. I mean, we're getting this, and that's why only 4 legitimate, at least what the city claimed were legitimate, harassment claims were filed within that last 3-year period out of 13,000. So I know, let's expand tenant protection so that we can inconvenience more landlords, and that's basically what we're dealing with.
Yeah. And here we have Peter. He says, when we do sell, we're possibly going to 1031 exchange the property into a 2 unit somewhere in OC. I assume that in general, OC is a little more favorable. Yeah, it's more favorable today for sure.
It is, however, we have Santa Ana started some gruesome rent control. And also, I just found out that Costa Mesa, where is that? Costa Mesa started some sort of a limited uh, rent control in excess of what statewide rent control is. Remember, ladies and gentlemen, when you talk about cities in the state of California, every city has rent control. Every city, because it's statewide rent control. So unless there's a local rent control, then you're under statewide rent control unless you are exempt.
Right. Joseph, are there any associations that are suing the city? And I would include individuals. Some of the larger owners also sue. Uh, you had mentioned that there's a lawsuit for the relocation.
Yeah,
Is
the economic displacement.
yeah. So other than that, are you aware of any lawsuits right now that are working their way?
That's one I know that's been going around the court system there. I mean, there should be everything. This fair market value, where if I have a Section 8 tenant, I can't do an eviction. I mean, this is just stopping me from basic contract rights. So, and this is not endorsed by the state of California, who created the statute dealing with unlawful attainders. These are local municipalities saying, I don't care what the state says. I'm saying that you can't serve a 3-day notice unless it's above a certain amount. This is just creating a situation where landlords have to wait for their rent. I mean, there's no basis for this, and there's no other industry that is under the attack as other than residential income property owners.
Right. All right. Well, hey, thank you for connecting with us on a Friday. And we hope all of you have a good weekend this weekend. And anyway, any parting words for us there, Dennis?
Just stay vigilant, really become a member of the Apartment Owners Association, read their magazine. It's invaluable, the things that you'll find in their magazines, and attend the seminars both online and certainly come out to April 16th to the Los Angeles Convention Center. It's an all-day free, did I mention free trade show? You'll learn how to operate your buildings much more efficiently and gain economic wealth. That's why they call it the $1 million trade show. And again, stick around to 3:15, and the old man, that would be me, is going to have a wonderful seminar, and I'll have a booth right by the seminar room.
Awesome. Thanks again, Dennis. Thanks everybody for joining. And I know there's a lot of frustration. And anyway, let's do what we can, and we continue to talk with the constitutional law attorneys, and wherever there's really a good lawsuit, we're willing to jump in on that. And it just kind of depends on, it's got to be something that that the attorney thinks is going to work for us. And so anyway, as things settle down, there may be something there, especially against LA County, that just seems like that's ripe for one. Anyway, take care, everybody. All right, my friend. Thank you so much.